Hello, everyone, and welcome. Thank you for joining us for today's webinar, Retail and Commercial Leases, Key Terms and Disputes, proudly supported by Matthew Folbigg Lawyers, one of our valued Platinum partners. It's fantastic to see the interest and so many of you online today, and I'm confident you'll walk away from this session with some practical insights to help better understand your leasing arrangements. My name's Brad Mooney. I'm the General Manager at Western Sydney Business Connection. Before we get started, I'd also like to acknowledge that I'm hosting and recording this webinar from the lands of the Darug people. I also acknowledge the traditional custodians of the various lands on which you all work today and pay my respects to the Aboriginal and Torres Strait Islander people that may be joining us today. At The Connection, we're committed to giving our members access to valuable business resources, and it wouldn't be possible without the support of our fantastic partners. The Connection is super proud to be partnering with 6 incredible businesses to ensure we can continue to deliver these high-quality webinars today at little or no cost. I'd like to thank again Matthew Folbigg Lawyers, Campbelltown City Council, Motivate Sports, Rarekind, world-class teams, and our newest Platinum partner, Yarpa. Onto today's topic, what's the difference between a retail lease and a commercial lease? Do you know your rights and obligations? And how do the Retail Leases Act and unfair contract term provisions apply to your lease? These are really important questions for both lessors and lessees. And in today's session is designed to help you navigate the legal landscape and provide you with more clarity and confidence. We're pleased to be joined by Michael Stevens, Principal Lawyer at Matthew Folbigg Lawyers. Michael brings a wealth of experience in commercial law with particular expertise in corporate governance, insolvency, and business advisory. He understands the value of clear, practical legal guidance, especially when it comes to lease negotiations and disputes. So without further ado, let's dive in, and I look forward to catching up at the conclusion of this webinar to assist answer any questions. Over to you, Michael.
Thanks, Brad. Hi, all. Michael Stevens, Matthews Folbigg, Property Principal and Commercial Principal. I'll just bring up our presentation. Okay, so today's about what's the difference between a retail and a commercial lease, and when do you need one and when do you don't, and what terms, what protections you get in a retail lease that you don't in a commercial. In New South Wales, the retail leases are protected by the Retail Leases Act 1994, and I think the important thing to remember is any provision or section of the Act in the Retail Leases Act overrides any lease term that you have in a Retail Leases Act. So you need to be aware, if you have a retail lease, what you're entitled to or what your rights and obligations are as a lessor and a lessee in the Retail Leases Act. So I've done terms of interest, protections, rights and obligations under the Retail Leases Act, and I've done common disputes that you have in retail and commercial leases that you should be aware of. And this paper will be made available to everyone to use as a ready reckoner, really. That's the way I look at it in relation to negotiating, renewing, or even exercising options to renew the leases. So I'll just go to the first section. Okay, it's just a bit slow, just a tick. So here's the outline, and we'll go through it as we go through. But as you can see, there's a full content of information here. So that's why we should be using it, or you can be using it as a reference guide when you're going in and entering into new leases. And that this will apply to retail and commercial leases, and we'll go through the difference shortly. So onto what is a retail lease. In 3 words, a lease or less, a retail lease is when goods or services are sold to the public. It came into effect in 1994, so it applies to variations of lease after that date if there's long-term leases. But usually from 1994, there's new leases being entered into. It relates to any business that's listed in the regulations of the Retail Leases Act, and it describes shops. I think there's about 80 different shops that are businesses that are listed, such as from bakeries, cafes to baby supply shops, but it's in relation to goods or services sold to consumers. The public will count as a retail lease, and any business or any business located in a retail shopping centre. So if you're in a retail shopping centre and say, for instance, a you're a political shop for a specified period of time, you may be counted as a retail lease and have to comply with the Retail Leases Act regulations. It also means that a retail lease applies to leases that are longer than 6 months and less than 25 years. So we'll go to what's excluded from retail leases. Anything over 1,000 square metres. Any business or any shop that's managed by the lessor is not a retail lease. And then the rest are pretty obscure car parking, vending machines. They're not retail leases. I've had a fair bit of experience in the last 25 years as to what disputes come up, and this is one of them. When does a lease commence? Is it on the signing of the lease? Is it when the lessee moves in without having signed the lease? Or is it when rental is paid for the commencement? So it's either of those ones, taking possession, paying the rent, or when you sign the lease. It's obviously preferable that the lease is signed before the parties move in. However, sometimes that's not possible or practical. For instance, when there's a sale of business by the lessee to another party, and they've set a date, and the parties haven't arranged for a deed of assignment of a lease or a new lease. If there's heads of agreement entered into, that may have to suffice until a new lease is signed. Not preferable, but that's the practicality of what happens when a lease is not ready to be signed by either of the parties. I'd strongly recommend that a lease agreement be signed before a lessee moves in to protect the lessee and the lessor. However, sometimes it's not practical. Now, key money is a common concept in relation to commercial leases, which commercial leases are obviously non-retail leases. They apply to offices, warehouses, industrial sites that are not selling direct to consumers. So a big one for key money is childcare centres. I've seen often that the lessor, the landlord, requires that key money, an amount of money as an incentive to the lessor to choose that lessee be paid. That doesn't go towards paying for any rental amount. It's just a payment of money to convince the lessor to choose that lessee. That is not allowed at any stage of a retail lease, any stage of the renewal, extension or assignment. So if that's in a retail lease, especially the retail leases that aren't using the Law Society of New South Wales terms, they may have terms in there that are contrary to the Retail Leases Act. So this presentation is really trying to put forward what both the lessor and lessee rights are, and what they're entitled to negotiate and what they have to include in a retail lease. In relation to the lessor costs for entering into a retail lease, they have to pay their own costs in relation to entering into a lease, and any amendments requested by the lessee. That only applies up to when a disclosure statement is provided by the lessor and the lessee signs that disclosure statement, agreeing with the principal terms of that lease. So there's an opportunity for the lessee to request amendments prior to signing the lease and prior to providing the disclosure statement. The disclosure statement is in effect a summary of the lease terms, and it's been authorised by the government regulatory authority to be provided in addition to the lease. If there is a transfer or an assignment of the existing lease or a sublease, the lessee leasing out a part of the lease during the term of the lease, the lessor can claim those costs incurred for the assignment and sublease. And the lessee is usually required to pay the lease registration fees in relation to the initial lease. Another protection under the retail lease is usually every 12 months, and unless you've got a very good lessor, the rent will go up. And there's lots of different ways to do it, and these are the usual ones. The percentage one is the one that I probably prefer for both a lessor and a lessee. The consumer price index, the inflation rate, as February 25, I think it's a bit higher now, it was 2.4%. They usually say that in commercial leases, the higher of a percentage or consumer price index, you can't have that in a retail lease. You have to choose one or the other. That's just another consumer protection for the lessee. So that's what a ratchet clause means when you're choosing a market rent review. So and that's usually at the end of the lease term, and you have an option to renew. It's agreed between the parties what the market rent will be, or an agreed valuer or someone chosen by the Law Institute will choose a valuer to determine the market rent. But you can't have a term in the lease to say the market rent can only go up. The market rent can go down. It often doesn't. However, it does go down in instances where there's either a rezoning of commercial business premises, business zones, or there's renovations happening or demolition in the area. Sometimes the market rent does go down. So the Retail Leases Act obviously says under Section 18 that you can't have, for a market rent review, that the rent can only go up on a market rental determination. These are clauses, relocation and demolition clauses. They're often not in a retail lease, but they're extremely important to protect both the lessor and the lessee if, for some reason during the term of the lease, which may be 3 years, which may be 5 years, the lessor anticipates that they may need to do some extensive renovations, or that there may be a rezoning in older suburbs where there's old buildings. Sometimes they have demolition, the council approved demolition of areas to do new areas, new business premises. So they're very important. The relocation clause provides the lessor with the ability to provide the notice to move the lessee to another premises in a different building, obviously, or even a different level, and the lessee would be compensated for the relocation costs. The lessee has a month of receiving the notice to determine whether they do or don't want to move. If they don't want to move from the premises, they don't have an option to stay. They can terminate the lease, and they can, with 1 month's termination notice, and they can find a different premises. So the relocation clause protects both parties, and the demolition as well, but instead it's a 6-month notice, and the lessee is entitled to compensation any fit-out costs it's incurred, and the lessee can't dispute a demolition notice unless, once the lessee's moved out and the lessor doesn't actually proceed with the demolition, the lessee can claim damages, loss of business profits from the lessor if the demolition doesn't proceed. So they are two often not used clauses, but they are important in relation to, and that both parties should be aware of those, and the lessee should be asking, is there going to be any renovations or demolition of this premises, especially if it's a long-term lease between 5 to 10 years. Again, along the same lines, under the Retail Leases Act, any disturbance caused by the lessor, the lessee is entitled to compensation and rental reduction. Now, that disturbance means disturbance to loss of use of the premises and reduction in business, and that has to be caused by the lessor. Now, you won't find that usually, okay, in a normal retail lease prepared by a lessor if it's not a law society lease. So I think my recommendation to both lessor and lessees is that if you're going to use your own version for a lessor of a lease, it needs to be compared to a law society lease. If I receive a lease acting for either a lessor or a lessee and it's a non-law society lease, the first thing I do is I do a comparison of what clauses are in and what clauses are out that are not the same as the law society lease. The Section 36 of the Retail Leases Act goes a bit further than Section 34. It says damage caused by any party or event, the lessee can claim rental reduction, and the lessee can terminate that lease on 7 days' notice if the lessor hasn't repaired or rectified the damage. And that is damage caused by any party or any event. So not just the lessor's actions causing the damage. So that obviously includes natural events, third parties, say for instance, a delivery driver dropping off some goods and they accidentally, I don't know, set the premises on fire. There's insurance cover to cover that. There's obviously a requirement for public liability insurance and business interruption insurance. So that insurance cover probably comes in to cover that loss, but the damaged premises, I think Section 34, I'll just check, is in the law society lease, damage caused by the lessor, but Section 36 isn't. So it's again, it's knowing your rights as to what should be and shouldn't be in the lease. So Section 36 is in the law society lease, Section 34 isn't. So again, Section 36 probably covers instances under Section 34, but Section 36 is in the law society lease. It's not rare, it's rarely in a lessor lease, and I act for both parties, and it should be considered as being included in any lease. A very popular topic, obviously, with lessees is how do I get out of this lease? My business is not going well. The agent for the lessor won't let me out, saying I'm liable for the duration of the lease term. There's 3 years to run. What do I do? It's got to ruin us. At the end of a lease, when the lease is ending, the lessor has to provide 6 months' notice prior to it ending that the lease is going to end. Usually the agents do this. If the lessor does not provide that notice, the lessee can seek to extend that lease for a period of 6 months if the lessor does not provide the notice more than 6 months out from the end of the lease that the lease is ending. So agents usually do that on behalf of the lessors, but often it doesn't happen, and often the lessee obviously is going to agree with the lessor to renew it or not, but sometimes it doesn't, and there's case law on it. So lessees obviously and lessors just be aware of the rights of providing notice before the lease ends, 6 months before, and if no notice is provided by the lessee can issue a written notice within that 6-month period that it wants to continue on after the end of the lease, and that will apply for an additional 6 months. Now, also under the retail leases regulations, the lessor has to provide a disclosure statement setting out the principal terms in a lease, because sometimes a lease can be 20 or 30 pages and they're difficult to read the first time. and they're difficult to sometimes for myself as well, especially when they're using a non-standard law society lease. And I know that a lot of larger organisations use their own terms. However, there has to be, and there is for a lessee, the opportunity to negotiate and amend those terms that are provided prior to the lessee signing off a disclosure statement and handing it back to the lessor. So lessees need to be aware that they have that opportunity to negotiate the terms of the lease, because a lot of the time they just don't realise that the lessees can negotiate these terms. And the lessors and the agents don't necessarily offer or provide that advice that they have the opportunity to negotiate terms of a lease that have been provided to them. So the lessor disclosure statement, the lessor has to provide that disclosure statement prior to entering into the lease with the lessee. And that just provides the principal terms. It's quite detailed actually, and it has terms in there that aren't always included in the lease agreement, such as proposed works, and that's very important, that the lessor intends to take out. And it has also, I'll just get it here. It has exclusive use. If the business is to have exclusive use, the business to be exclusive within the retail building. So it has a few things that aren't necessarily in a lease agreement that have to be disclosed in the disclosure statement, and that's a document that's been prepared by the regulator, and they have to include those terms. It's a form under the Retail Leases regulation, and they have to include all those terms in the disclosure statement. And that obviously has a detailed schedule of outgoings, and it's specified what outgoings are to be paid by the lessee. And if there's terms in that disclosure statement which aren't correct or are inconsistent with the lease or misleading, the lessee has rights to not pay outgoings if the outgoings are just not in accordance with the estimates provided, or they can terminate the lease if there's false or misleading or incomplete information. So the disclosure statement is important. It's often a last minute overlooked document, but it needs to be part of the process that lessors provide to lessees, and the lessee has to give that signed acknowledgement back that it agrees with the terms set out in the disclosure statement. Another difference in relation to commercial leases and retail leases is that if there is a dispute, say that the lessee terminates for damage to premises that's not rectified by the lessor under Section 34 and 36, I think it is, of the Retail Leases Act, they can't go to the local district Supreme Court at first instance. They have to go through the New South Wales regulator, which is New South Wales Fair Trading, and they've set up a small business commissioner for a mediation. That's a requirement of both the lessor and the lessee prior to taking any further action in relation to seeking compensation or loss of profits for any wrongful act or omission by either party. If mediation is not successful, and it's usually pretty good in my opinion, because it gets the parties there, and sometimes they turn up with their lawyers, and they realise that it's costing them both money and time. So a commercial resolution is always better than having to attend a lawyer's office for the next 2 years. So if mediation is not successful, there's a tribunal that's set up. And if you commence proceedings in a court, you'll get referred back to the New South Wales Civil and Administration Tribunal. And that's I think they call it a user-friendly environment where they discourage solicitor representation. And they do that for a reason, to ensure that the parties have to turn up on each occasion and are forced to negotiate. But you can seek leave for legal representation. NCAT has a jurisdiction up to $750,000. So hopefully, sometimes not when there's larger parties, lessor and lessee businesses, but the jurisdiction's up to $750,000 and a 3-year time limitation, not the usual 6-year time limitation under the statutes of limitations. And it deals with the whole range of issues under a lease, and also unfair contract terms, which we'll get to, and unconscionable, misleading, deceptive conduct, which is now part of a range of claims that can be made by lessor or lessee against each other. And it's obviously cheaper than going directly to court. So there's a compulsory mediation clause under the Retail Leases Act, but not obviously for commercial leases. They can go straight to court if there's a dispute. So there's quite a number of protections under the Retail Leases Act that are there for the lessor and the lessee to obviously be able to rely upon. And it helps as a dispute resolution mechanism, not having to go to mediation, but saying to the other party in a retail lease, well, they're my rights under the Retail Leases Act, and that term should be in, or that term's inconsistent with the Retail Leases Act and is void. It's all about trying to remember or know your rights when you're negotiating a lease and trying to resolve a dispute, such as a lessee wanting to leave early. There are certain obligations on the lessor to mitigate, to reduce their claim by trying to find another tenant. So the Retail Leases Act is a very important tool to refer to for both parties. So with commercial leases, it includes everything that doesn't really involve sale of goods and services directly to the consumer, the public. It includes leases that are less, retail lease doesn't apply to leases that are less than 6 months or more than 25 years, but they're usually commercial leases they include offices and warehouses, industrial sites, and non-consumer sales. So commercial leases include any terms that are agreed between the parties. So the terms that are not in retail leases, that are usually in commercial leases, that the lessee has to pay the costs of the lessor, the lessor's costs incurred in the lease negotiation and preparation of the lease. The lessor can claim the costs of any amendments throughout the term of the lease to be paid by the lessee. And there's no compulsory mediation when disputes arise in a commercial lease, which means that they can go straight to the courts, either parties. But I would recommend that there be a compulsory dispute resolution clause or a mediation clause in a commercial lease. That stops the lessees or the lessors from getting the wrong advice unless it's for an injunction, if there's something urgent to be obtained from the other party, as in it's an unsafe premises and the lessee's not maintaining the premises and it becomes a fire safety hazard. They may need urgent orders for eviction. That's an injunction that you can go to the court for, but there should be compulsory mediation clauses, dispute resolutions in all commercial leases. Now, usually for both retail and commercial leases, retail leases, there's a requirement that the lease be registered if it's for longer than 3 years. And that includes the option to renew period. So if it's a 1-year lease with a 2-year term, that lease is required to be registered under the Retail Leases Act. When the lease is renewed or there's an option to renew, a variation of lease should be registered at the Land Titles Registry. However, if it's a lease under 3 years and it's not registered, and the lessee moves out, or the business is sold, or the lessor's building is sold, that lease, if it's under 3 years, goes with the land. So the new owner of the property has to honour the terms of that lease if the lease is under 3 years. So, and that's difficult to know if it's not disclosed by the lessor or the owner of the building that there's a current tenant in there from the solicitor doing the sale of that property. But that is a protection that a lessee has for retail and commercial leases, that if it's under 3 years, that lessee stays with the building even if there's a new owner of that building. So if the lease is over 3 years, obviously under the Retail Leases Act, or under the commercial lease as well, the new property owner is not bound by that lease and they can evict that tenant. So obviously the solicitor's doing the conveyance for the seller, and the purchaser need to find out whether there's a current lease in the building, the commercial building or retail building being sold. This is a favourite of mine: deposits, guarantees, securities, what happens with them. It's probably from my insolvency take on it. But if there's any cash given by the lessee to the lessor for a security bond, be it for 3 months, 6 months of the monthly rent, under the Retail Leases Act, that has to be given to the New South Wales Fair Trading Tribunal, and it's kept as a bond in a secured account. That ensures that the lessor doesn't abscond with that money, and it's held in escrow by a third party. So that's a pretty strict requirement under the Retail Leases Act, that the lessors have to give any cash received to the New South Wales Fair Trading Tribunal, New South Wales bond, to be kept until the end of the lease. Or if rent's not paid, they can access that bond and they can require the lessee to top up that bond. The issue is that if the lessee is in financial trouble and goes into liquidation, the lessor can't access that bond, and the liquidator of the lessee will be entitled to recover those bond monies directly from the New South Wales Fair Trading. So to protect the lessor's entitlement to those monies, they should be registering a security interest over the lessee company, if it's a company, to ensure that they have a secured interest over that cash bond. Once the lessees receive that cash as well from the lessee, sometimes and often I've seen they don't put it into the New South Wales Fair Trading bond. They're liable to penalties if that doesn't happen. So it's good procedure for the lessor or the lessor's agents to ensure, or the managers to ensure, that those cash deposits are paid to the New South Wales Fair Trading bond. So my preference for deposits is a bank guarantee. So that means that the bank holds the money on behalf of the lessor received from the lessee. And if the lessee goes into insolvency, the lessor can claim that bank guarantee, and the liquidator of the lessee is not entitled to that money. So it protects both ways to protect the lessor from security deposits is register a security interest over the lessee company if you receive cash and have to give it to New South Wales Fair Trading, or get a bank guarantee. My preference is always to get a bank guarantee. This is probably the most important for the viewers as to common lease disputes. So we'll go through each just quickly, just noting the time. But if you're going to get anything out of this seminar, this will be the page, and this will determine what terms should be in your lease at the start of the lease. So just have to be aware that these are the common disputes that I've seen. over probably too long a period. So relief against forfeiture just means that forfeiture means evicting the lessee, the lessor evicting the tenant from the premises if they don't pay their rent. And you don't need to provide any notice under any act for non-payment of rent unless the lease term itself says, the Law Society says you don't need to provide notice if they're 14 days beyond the due payment of rent, you can evict them without any notice. Now, not many people do that. Not many lessors do that because they want to try and keep the lessee. But if they're a continual breach of non-payment of rent, you can evict them without notice. However, the Retail Leases Act and the Supreme Court Act provide that if the lessee pays the rent back up to date and there's no other breach, 95% of the time, believe it or not, the lessee will be allowed to go back in regardless of how many times they've breached the non-payment of rent but they would have to provide their financial capacity to continue on to pay the rent. So as long as there's no other breaches, the court will grant them a return to the premises. However, there's got to be a certain limit as to how many times they're evicted and allowed back in. But if they provide their financial capacity, they're allowed back in by the court. So don't rush lessors to evict without notice. It's because if it's a big lessor and lessee business, obviously resolution by mediation is the best way, but the lessee has rights to get back in if you pay up to date. Outgoings is the second most discussed, disputed term or issue. And lessors, they need to provide every financial year before the end of financial year outgoings estimates. If they're not provided or those estimates are way off target for that year, the lessee has rights to withhold payments. Now, not many lessees know that. There's different ways to pay outgoings, obviously being incurred, or lessors want estimates paid and then accounted for. But there should be specific terms in a lease as to when outgoings are paid and estimates being provided, and they need to be specified as to the different types of outgoings that are incurred. It can't just be a global amount. And the lessor disclosure statement sets out each type of outgoing that's being incurred. My preference is for outgoings to be paid by the lessee when they're incurred. However, most lessors want estimates provided and amounts paid in advance and then accounted for at the end of each financial year. So there's different ways for outgoings to be paid. But the main issue is when the outgoings increase by 50% the next year, and there's no estimates provided, the lessee doesn't have to pay that unless the estimates are provided. Obviously, repair and maintenance and make good terms are obviously hotly contested. Usually the lessor is required for the structural repairs and maintenance and essential services, the taps, electricity wires, and the lessees for the internal fixtures and fittings and repair and maintenance of it. There should be pretty specified particular clauses depending on the type of commercial or retail premises as to what the lessee's obligations are. And the usual one is probably not a big topic, but the air conditioner. What happens if the air conditioner breaks down and it can't be repaired and the lessee's been servicing it annually in accordance with the terms of the lease? The lessor should be replacing that air conditioner because that's a fixture that the lessee's not going to take with them. So things like that need to be just properly put in the lease terms as to who's responsible for repair and maintenance during the lease term. And obviously when the lease ends, returning the premises to the original condition It should be specified in the lease as to who should be, or what the lessee is responsible for, and returning it to its original condition. If the lessor rents out the property at the end of the lease straight away, obviously the lessor doesn't incur any costs. The lessee doesn't incur any costs in returning the premises to the original condition. There's no requirement on the lessee to return the premises to the original condition if a new lessee is found and paying rent at the same or a greater rate. There's case law on a lessee disputing having to return it to the original condition if a new lessee is found. So the lessee should be aware of their make good obligations at the end of the lease. Obviously, in addition to the lease terms, if you're in a shopping centre or a larger premises, there's building rules and the strata bylaws, and that needs to be taken into account in relation to what other rights and obligations there are. And that will have obviously a duplication of common area rules and building hours. So we need to be aware of any additional documents, franchise agreements, building management rules, strata bylaws that the lessee and the lessor should be aware of. This was back to my previous mention of how to get out of it, or how to terminate or end a lease earlier for the lessee. There's no magic bullet here as to how a lessee can leave a lease, end a lease, without being liable for some part of the continuation of the lease term. The lessor has a duty to find another tenant to reduce their loss. There's also issues as to the lessee maybe trying to find a sub-lessee tenant to rent out part of the premises. However, that may not be practical. But usually a lessor solicitor will say, well, you're liable for the duration of the lease term. Well, that's just not right. The lessor has an obligation to try and reduce their loss by advertising for another replacement tenant. And if there's an argument as to that, the lessor has to provide evidence that it's made an effort to find another tenant. And if it can't find another tenant, well, that means that the lessor's claim against the lessee is reduced because the premises may not be fit for purpose. There may be some reasons why another tenant's not coming in. The getting a party in as a lessee, sometimes the lessors offer rent-free periods or reduced free car parking spaces. Obviously, they do that to get a lessee in. If the lessee receives rental-free periods and the lessee subsequently breaches that lease, the lessor can't recover those rental-free periods as lost income. There's been case law and they're being viewed as unfair contract terms. And the courts have said, well, that's the market rates that you provided, offering a rental-free period. So it's not actually a loss incurred because you've put that into your financial books as the market rate for that particular premises. So rent-free periods and rental abatements, reductions, incentives aren't able to be recovered in the event of any default. I've seen a couple, I haven't done it myself, but I've seen a couple of instances where lessors offer rent-free periods by way of a loan agreement, which is secured. They register a security interest over the lessee for the obligation to repay that loan agreement, which is basically the rent-free period. Say it's 3 months at 30 grand. So they give them a $90,000 loan. They only recover that in the event of breach. That's one way of getting around it. I would think that a lessee would have an argument as to disputing that loan agreement as being an unfair contract term. But we'll get to unfair contract terms soon. But that's one way to get around the rent-free periods. if if there's at the end of the lease, if there's equipment there on the leased premises, the lessor usually has a lease term that equipment becomes the property of the lessor and they can do what they want with it. However, there's an act that you have to comply with, and it happens often. You can't just dump it in the tip. There's certain rules and regulations. It's usually a 28-day notice period, and then you can sell or destroy. If it's over a certain amount of money, I think it's $1,000, you have to auction that equipment. And if it's personal items, you have to give them a 28-day notice before destroying those personal items. The assignment of a lease and subleasing or a new lease entered into, the lessor usually has to provide its consent subject to the new lessee coming in having financial standing. The lessor is entitled to claim their costs for any assignment or subleasing. And if a lease is assigned to a new lessee, the new lessee takes on the obligations of that lease from that date of assignment, such as for a sale of the lessee business, the new lessee takes on all the rights and obligations under that lease from that date on. Just wrapping up now in relation to a lease, unfair contract terms apply under the Australian Consumer Law. Unconscionable conduct, misleading and deceptive conduct has applied since 1998, I think. They're a little bit harder to prove. It's a commercial negotiation, but it's in the Retail Leases Act. Misleading, deceptive, unconscionable conduct applies. Unfair contract terms apply, and I think there's a fair few unfair contract terms that are in leases, and I've made a list there of what I think they are, and they should be looked at in a lease. Okay, I think that's it. I've gone through. There was a fair bit there, but it's just to use this as a ready reckoner in relation to entering into leases for the people here, for lessors and lessees. Thanks, Brad.
Thank you, Michael. That was really insightful. You covered off a fair bit of information in the
Probably
time,
too
which I
much.
think would have been really helpful to everyone. So I think now's a good time for anyone that has any questions. If you just want to put it either in the chat or in the Q&A, we've got a little bit of time now to run through some of those with Michael. Cassidy's also going to put Michael's contact details in the chat, and Michael's kindly made himself available if anyone would like to make contact or discuss some of this in more detail. We understand it's a pretty bespoke topic, and we may not be able to answer the questions, but now's a great time to put those through. I've actually just had one question that come through now, Michael, from one of the attendees, just saying, what are some of the common misconceptions about whether the Retail Leases Act actually applies to your lease?
Yeah. Okay. So if you're selling goods and services to the public, it's a retail lease. It doesn't matter where the shop is. Okay. So if I'm selling meat pies in an industrial complex and I've got a shop, okay, that's got to be a retail lease, even if it's in an industrial complex. And if you've got a license for 6 months and then you get a 2-year lease term, that license is covered by the Retail Leases Act as well. I've seen a couple of agents do that. I act for lessors and lessees, but I've seen a few agents try and get around the Retail Leases Act and charge key money. So if you're selling goods and services to the public, it's a retail lease.
Great. I think that's it's a really straightforward answer. I'm just going to see, does anyone else have any questions? Feel free to put them in there. Equally, also, as you can see now, Cass has put Michael's details in the chat, so you're more than welcome to touch base directly if you're not comfortable to ask or it's specific to your current situation. All right. Well, I can't see any more at this stage. And look, I think it's been really detailed in the presentation, which Michael's kindly going to make available to you. And the one question we have had's been answered. So I won't. We don't need to stay on here for the sake of it, but that really brings us to an end of today's session. And I just want to give another big thank you to Michael for his sharing his time and expertise, and of course Matthew Folbigg's lawyers for being a really strong supporter of our organisation and of course this webinar. If you have any follow-up questions, as I said, please reach out to Michael directly. Also, if there's anyone on here today that hasn't connected directly with WSBC, Cassidy will also put my details in the chat. More than happy to have a discussion about your business and WSBC more broadly at a time that suits. But I would just like to say thanks again to Michael. That was really good, and yeah, I think everyone else, on behalf of everyone else, thanks again. We look forward to welcoming anyone on here to our upcoming events. And other than that, I would like to wish everyone get back to it and enjoy their afternoon.
Thank you.
Thanks again. Take care.